everybody, we are from Group 4 and our group members are Ying, Lina, Fong, Koay Qe Yin, Chong Ko Win and Lim Li Shan. We will present the intellectual property and sport. My name is Ying and I will present the introduction part. Intellectual property IP can be defined as an invention of an individual or corporation about intangible or non-physical assets such as design, idea, or creation of logo, brand name, and picture. Furthermore, IP is being provided legal protection in order to allow the individual who are having their own invention or creation to get an acknowledgement or monetary gain. In 2020, the sports business were valued at $388.28 billion globally. In this case, the value may be equated to the pleasure of participating in or watching athlete event. A large portion of it is attributed to large quantity of intellectual property related to athlete appearance, brand, logo, and more. Besides, the intellectual property right is being implemented to advance a variety of game sport organizations and teams all over the world. In India, cricket has become more famous in the Indian society after 2008 with the help of the India Premier League (IPL). Apart from that, the advancement of internet and globalization of sport attract many foreigners worldwide to local regions, which require clear and robust broadcasting rights. For example, Football TV has secured the exclusive live streaming right to the South American Football Confederation Qatar World Cup 2022 qualifying match. According to the report, the annual direct economic effect of counterfeiting on the worldwide athletic goods and sportswear industry is about $50 billion. When the indirect effect on associating service is taken into consideration, the annual impact of counterfeiting is estimated to be $84 billion. Therefore, intellectual property like trademark, patents, copyright, and trade secret are critical elements in protecting the brand and avoiding the loss in revenue due to the sale of counterfeiting products.
Hi, my name is Lina Shan Fong from 3BDS. I am going to present about the history of intellectual property. One of the earliest mention of intellectual property protection is from Cheow in the Greek colony of Cyprus were award year-long monopolies for developing certain culinary delights. From Roman time to the founding of the Florentine Republic, many franchises were granted right to the intellectual work. The scholar believe the legislation of N to be the first modern copyright standard. There are various international accords have broadened the geographic reach of intellectual property protection, include most of the world. The WIPO, a specialized organization of the United States nation, in conjunction with several treaties established by the WTO, protects rights worldwide. The IP Day is held every year to remind people how important it is to give creator and inventor rights to their work. The reach of the goal IP and sport was the 2019 World IP Day theme. The next part I am going to present about the copyright in sport industry. Copyright is a form of intellectual property law that protects original content from unauthorized duplication or use. The section of the Copyright 1987 states that copyright owners have the exclusive legislation to control over the creative work in Malaysia. In Malaysia, the Act outlines that this work shall be eligible for copyright such as broadcast, artistic work, and recording. The Act states that the content broadcast or transmit from the venue will be considered copyright works. Therefore, if a third party utilizes the broadcast of his channel, it will violate copyright. Because of the immense popularity of sport content and internet content sharing, the copyright infringement of transmission sport content commonly happens globally. As a result, the commercial sports sector has cautiously approached new live streaming technology. Because they are concerned that unofficial rebroadcasting of athlete events might not turn licensed sport newscasts into marketable. Some athletic sports such as synchronized swimming, dance, gymnastics, and skating are likely to fulfill the originality criteria of the author intellectual work. The next part I am going to present about the patent law in sport industry. A patent is an exclusive right granted to the inventor of the patent process, technique, design, or invention of a certain period. The provision of a patent protection is to prevent others from manufacturing, using, selling without the permission of the patent owner. In the development of the sport industry, patents play a crucial role throughout their technology life cycle, allowing the competitive innovation to be protected and licensed to other parties to increase income. In addition, the patent advancement in the sport industry have enabled them to develop and become more readily accessible in the marketplace.
My name is Chong Ko Win. I will present about the trademark in sport industry. First, a trademark is a symbol that identifies the goods or service of one company from those of another. Trademarks allow people to select and purchase things based on the belief that objects with a certain emblem will deliver quality and performance. Sections 135 of the Trademark Act of 1999 established that the infringement of a trademark or brand is recognized as a crime and the offender can face criminal charge. Many sports organizations also benefit on their brand value by licensing their trademark and other intellectual property to third parties to make items such as clothes, accessories, footwear, and more. The trademark law and how to secure such access is therefore critical to the sports sectors, since if the trademark rights are not safeguards, then customer will be unable to utilize the brand as an accurate source identifications. For example, the Rise of Champions is used in FIFA and IPL. Each team has its own logo and emblems. Lastly, the sport sponsorships are often dependent on the trademark rights. Next is personality rights in sport industry. Personality rights pertain the rights relating to certain personal qualities, personality characteristic, commercial usage and exploitation of persons. These rights are intended to protect a celebrity name, image, likeness, and any other distinguishing feature of their personality, including their right to privacy. Personality right in sports should be the usual for players to register their name for trade and commit as the trade name or trademark. Individual athletes such as Lionel Messi and Tiger Woods have become international brands as a result of their celebrity or becoming a brand ambassador for a certain brand. Some athletes can earn a lot of money from their image rights. Coca-Cola, McDonald's, and Samsung continue to spend in sport sponsorship to guarantee that their brands are connected with sport brands. Image rights and their use in the sports sector are new concept in Malaysia, and many local athletes miss out on the revenue generate potential. For example, Dato' Lee Chong Wei, he makes the majority of his money through tournament victories, but he also makes a lot of money by controlling the use of his image in the endorsement deals with companies like 100 Plus and Unex. Trade secret in sport industry. Trade secrets are the part of all winning strategy that is not disclosed to the public for a team or the secret substance in their gear that make the games easy to win or any other elements. Another trade secret that must be kept from being utilized by competitors is data analytics that entail analysis how another teams play, their competitive advantages, and the team's strength and weakness during the last several sports games. In Malaysia, the terms trade secrets and confidential information are synonyms, and this is formally recognized by Malaysian law. A trade secret is protected as long as it retains a trade secret all time. For example, sports drink formulations in the sports industry. Survey methodology uses by professional poster recipes, innovative technology that have not yet been patented, marketing tactics, manufacturing procedure, and computer algorithm are all the examples of possible trade secrets in the sports sector.
Industrial design rights are typically an outgrowth of trademark law and copyright law and are distinguished mainly by the fact that the pertains they relate first to the aesthetic of the object and does not include anything technical or linked to the product's function. Therefore, it is highly imaginative and attempts to improve the aesthetic of the product to be used so that when someone subsequently purchases the product, they can identify it with the theme or the player's design. In most of the country, industrial design are required to be registered so that they can obtain protection by the industrial design law. It is, however, only granted in countries in which the design has been registered. The registration of a design somehow doesn't address how it works, but rather provides protection for the graphic aspect of the object, and the design has to be new or original to be registered. Thus, following the implementation of Industrial Design Act 20,000, manufacturers generated significant profits after obtaining registration. Distinguished they are not only by their value but also by their appearance, which play an important role in attracting buyers to purchase it. Internet and related advertising campaigns have now significantly increased the value of domain names and their usage as commercial identifiers. Domain names contribute to a brand identity, portability, and search engine optimization. Amongst other reasons, the World Intellectual Property Organizations maintains and expedited dispute resolution mechanisms for Internet domain names in compliance with globally recognized rules. In sports, a lot of the information is shared and events are broadcasted via the Internet, which adds a lot of market value to branding, and Internet is a low-cost means of reaching out to the public and raise the awareness or knowledge of sporting events, athletes, and others. Moreover, exclusive domain names linked with the team constitute an excellent source of advertising and brand growth. Licensing and franchising play a significant role in making profits from sporting events, which the licensee or franchisee obtains the authority to sell exclusive goods of the intellectual property owner, which is associated to exclusive teams, clubs, and others, for the intent of developing goodwill or brand name reputation. Since sports organization and other rights owner could safeguard and expand their revenue generating potential by obtaining intellectual property and strategically employing it. Holders of intellectual property rights such as patent, trademarks, and copyrights may license these rights to others for a fee. For instance, technology licensing may be a viable choice for organizations developing sport-related equipment, gadgets, or devices. Technology licensing could be used to license in innovation created by other companies, as well as to generate additional profits by licensing out domestic technologies. Furthermore, licensing is important as sport licensing is used by organizations in create relationship with their supporters. As an example, the European football teams have created a large fan base in places like United States and Middle East by negotiating licensing and product partnerships and reinforcing these deals with the summer visits after European football seasons.
I'll be presenting for the sports-related intellectual property case in the report. The first case is the USOPC versus Puma 2021. The party involved are the USOPC United States Olympic and Paralympic Committee, who is the plaintiff in the case, and the Puma SE and Puma North America Incorporation, who act as the defendants in the case. USOPC sued the Puma SE and Puma North America Incorporation for infringement of trademark, unfair competition, fraudulent designations of origin, and deceptive business practices. Puma, who is not the Olympic partner, member, or sponsor, employed the game marks switched on by the USOPC without authorization of them in their special series of apparel products producing, distributing, promoting, selling, and even advertising. Besides, Puma declared war to USOPC by initiating aggressive approach, filed the petitions to have cancellation on 7 trademarks which is owned and registered by the USOPC. Puma also attempted to register the trademark which tied to the brand of Puma with the Olympic itself to gain the benefit from the illusions of association or partner with Olympics. Action arises under the Ted Stevens Olympic and Amateur Sport Act. According to the 36th United States Code, Chapter 220506, the corporation has exclusive rights to use the name, sales, emblems, and badges of United States Olympic Committee under the Lanham Act 1946. As according to 15 United States Code Chapter 1051 etc., Puma is undermining the sponsorship activities create confusions to consumer on the official Olympic sponsor. While in Colorado revised status under the Title 6 of Consumer and Commercial Affairs 6101 etc., cited for the Colorado Consumer Protection Act 2. In Colorado common law, Puma actions arises under the trademark infringement and unfair competitions. In Declaratory Judgment Act, as according to the 28th United States Code 2201, declaration can be done by challenging the game mark's registration, whether it is valid and enforceable by the plaintiff. In the end of the lawsuit, the court made declaratory judgment that challenge games marks registrations are valid and enforceable by USOPC. The court grants Puma on treble damages to USOPC for willful infringement and punitive damages. The court also awarded USOPC the cost of suit, reasonably attorney fees, pre-judgment, and post-judgment interest.
For the conclusion part, the sports sector would not have gone to its current state without intellectual property safeguard and incentive. The revenue of the country can be increased with the help of IP right by selling athlete appearance and encouraging international trade. A patent troll, often known as a non-practicing entity (NPE), purchased generally patent and bring infringement law against firms that actually use the patent. Sport brand holders, for example, have filed infringement claims against big sport corporations such as Adidas and Run Testing. Infringement penalties must be served enough to dissuade protection of further. The proprietor also be subjected to obtain a registration or an agreement with appropriate terms and conditions in maintaining the value of sport and athlete assets while also vigorously safeguarding the intellectual property against infringement and misuse. For media and broadcasting rights, a policy about domain name management and protection should also be adopted. As a result, intellectual property is not only a critical component of business activity, but it also essential to safeguard the sport industry and its excel since sport is becoming more commercial. Stay all for us. Thank you.